Welcome to The Explainer. Today, we're going to dig into something that's, well, it's confusing and, frankly, pretty stressful. What happens when you get sued for a debt by a company you've never, ever heard of?
So picture this, right? You get a letter in the mail, maybe even a court summons, and it's about a credit card debt that, yeah, you might recognize. But the company suing you? A total stranger. So what's the deal? Is it a mistake? Some kind of scam? Well, the real answer, it's usually a lot more complicated than that.
The thing is, your debt has probably been on this long, winding corporate journey. So the company demanding payment today, it's very likely not the same one that gave you that credit card in the first place.
So how in the world does that even happen? How does an account just jump from one bank to a completely different one? We're going to break down exactly how this works. Because honestly, understanding this is step one to knowing what your rights are. Okay, so the most common reason for this name game, it's all about corporate mergers and acquisitions. I mean, big banks are buying each other and shuffling things around all the time. Your debt, it just gets swept up and carried along for the ride.
And you can see just how common this is. Take MBNA, for example. If you had one of their credit cards, odds are that account turned into an FIA card services account after they merged with Bank of America. Same story with Bank One. A lot of those old accounts are now being collected on by Chase. So see, the name on the lawsuit is totally different, but the debt itself has the same starting point.
But it's not always that simple. It's not always just a one-step move. Sometimes a debt gets passed along like a hot potato, making it way, way harder to connect the dots between who you originally owed and who's suing you now. This is a perfect example of just how messy it can get. Let's follow the journey of an old Providian credit card account. Okay, so first, Providian gets sold to Washington Mutual. You probably remember them as WAMU. Then, WAMU goes under during the financial crisis and the FDIC steps in to take it over. From there, the FDIC sells off WAMU's assets to someone else, like Chase. And here's the kicker. The company that's suing you has to be able to prove every single one of those handoffs. And that brings us to the most important part. A company can't just waltz into court and say, hey, we own this debt now. No way. They have to prove it, and not just with any old piece of paper, but with actual legally admissible evidence. So, what's the difference between real proof and, well, junk? Courts have no time for hearsay. A debt collector can't just print out a Wikipedia page or a news clipping about some bank merger and call it a day. They need the real deal, official documents, like a merger certificate that was filed with the state or an official notice from a government body like the FDIC.
And this really happened. There was an actual case where a collector tried to prove JP Morgan bought Bank One's credit card business by handing the judge a New York Times article and a printout from Wikipedia. The court just threw it out. Flat out. That kind of stuff doesn't even come close to meeting the legal standard.
And this quote from another case really nails it. A collector had a letter from a federal regulator that allowed one bank to buy another. But the court basically said, so what? Just because you have permission to buy something doesn't prove you actually bought it. You need proof that the sale actually happened, the transaction itself.
All right, so if you thought that was complicated, buckle up. Because sometimes the bank that's sending you your monthly statement, they might not even own the right to your payments anymore. This is where we get into a really complex financial maneuver called securitization. Okay, so what is securitization? Put simply, a bank takes a whole bunch of debts, what they call receivables, bundles them all together, and then sells the right to collect on those future payments to a separate company, usually a trust. It's kind of like a songwriter selling the future royalties to a hit song. They still wrote it, but now someone else gets paid every time it's on the radio. But here's the really tricky part. Even after the bank sells the right to your payments, they often keep servicing the account. That means they're the ones still sending you statements, handling customer service, all that stuff. It's like a farmer who sells the rights to this year's apple harvest but still takes care of the orchard. So the bank still has the relationship with you, but a totally different entity, that trust, might actually own the right to your money.
So what does this all mean? It means when a big bank sues you, you have to ask, who are they in this story? Are they the original owner who never sold the debt? Are they just the servicer suing on behalf of the trust that owns it? Or did they actually buy the bad debt back from the trust? Each one of those roles requires a completely different kind of proof. And the key to this whole puzzle is a document called the Pooling and Servicing Agreement, or PSA. You can think of it as the master rulebook for the whole deal. If a bank is suing you as the servicer, or if they claim they bought the debt back, they have to be able to show this agreement. It's what proves they have the legal right, the standing to even be in court.
Okay,
So, we've gone through corporate mergers, these crazy long chains of ownership, and this whole financial maze of securitization. So what's the big takeaway? What's the bottom line for you if you're the one facing a lawsuit from some company you don't recognize?
It's this, and it's super important. The burden of proof is 100% on them. It is not your job to untangle their messy corporate history. It is their legal duty to prove a clear, unbroken chain of ownership, connecting every single dot from your original creditor all the way to them.
And that right there is the key distinction. The lawsuit isn't just about, do you owe this money? It's about, do you owe this money to this specific company? They have to prove both things. And if they can't prove they are the correct party to be collecting the debt, they have no right to collect it. Period.
Which really leaves us with a powerful final thought, doesn't it? In this whole complicated world of modern debt, that one simple question, can you prove you're the one I owe? It's not just a fair question to ask, it's the fundamental legal question that their entire case hangs on.